I have joining me virtually a panelist that will help give a sense to all of this and break them down. I have a senior advocate of Nigeria, Mr. Ebonolu Adegboruwa, he joins us virtually, and also Dr. Muda Yusuf, an economist and a former DG of the LCCI. Equally, we have Mr. Yomi Fagbenro, West African tax leader at the Deloitte. And from our Abuja studio is Mr. Emmanuel Anyegbulam, the Executive Director, African Center for Parliamentary and Constitutional Studies. He's also a lawyer. Let's begin with the Senior Advocate of Nigeria, Mr. Ebua Olu Adegboruwa. Thank you so much, Mr. Adegboruwa, for your time tonight. Give us a sense of what that pronouncement of court is today. That stay or what they call status quo to be maintained. What does this mean?
Thank you very much for having me. It's been reported widely that the Court of Appeal sitting in Abuja today directed parties before it in the pending appeal to maintain the status quo whilst the rest of the appeal is being heard. Generally, in law, when a court is seized of the facts of a case, you are supposed to allow the court determine the issue on the merits. You are not supposed to resort to self-help or take steps that may overreach the hearing of the appeal on the merits, so that even if judgment were to be granted, it may have become like a fait accompli, whereby parties may not be able to restore themselves to positions which they were before the appeal could be heard. So I take it that first is to know that the order should be limited to the parties to the appeal. And to that extent, I think it is the Rivers State government and the Federal Inland Revenue Service. Now, to that extent, I believe that an order of court should ordinarily be limited to the parties before the court, because a court will not have jurisdiction to make an order against the whole world. So that takes us to the issue of the involvement of the Lagos State government. I believe from the reports and the facts of the case is that Lagos State government applied to be joined as a respondent in the appeal because it claimed that it will be affected by the outcome of the appeal. But the application for joinder has not been heard and pronounced upon on the merits by the Court of Appeal. So to that extent, it's a matter for consideration whether Lagos State government can be bound by the order when it has not been officially joined as a party in the suit, because for all intents and purposes, the application for joinder could be refused by the Court of Appeal and it may be granted. So it will be speculative, therefore, and overreaching for anyone to extend that order to the Lagos State government that has not been joined officially as a party in the suit. Then the second issue, which you have alluded to, is to define the meaning of status quo. Naturally, it will mean the position the parties were as of the time the order was made. And if we were to interpret this in this circumstance, you will know that the subject matter of the appeal is the power of Rivers State government to collect value-added tax. Now, after the judgment of the Federal High Court in Port Harcourt, the House of Assembly in Rivers State, rightly or wrongly, has since passed a law authorizing the collection of value-added tax in Rivers State. Yesterday, the House of Assembly in Lagos State also passed a similar law, and that law has since been assented to by the governor of Lagos State today. I doubt whether these two pieces of legislations are subject to the appeal pending. If they are not, specifically, it therefore means that the order to maintain status quo will not be extended to legislations that are already pending, because it is not the practice of the courts to interfere in the exercise of authority of other arms of government, especially the legislature. So until that law is brought before a court and a pronouncement is made one way or the other, we cannot extend the order to maintain status quo to a pending and subsisting legislation duly made by the House of Assembly of Rivers and Lagos State. So for me, therefore, the status quo will be in respect of the subject matter of the judgment of the Federal High Court in Port Harcourt. And generally speaking, I think that it would be good for parties to find an amicable means of resolving this. And I say it with all due respect to the federal government and the state government. The All Progressive Congress voluntarily made a promise to the people of Nigeria when it was canvassing for votes in 2015 for restructuring. In its manifesto, Article 1 says that it will amend the Constitution to achieve devolution of powers, to achieve state police, and then also ensure that there's fiscal federalism. What is going on now is beyond value-added tax. In various other areas of our national life, we must begin to find a way to shed weight of the federal government, to allow the states to exist, to allow the local governments to exist, and to run a proper federation, and so that we can stop this feeding bottle federalism that we're operating, whereby people go to Abuja on pilgrimage every month to collect bailouts. So I think that is at the core of it. And it is because the APC has reneged on its promise for devolution of powers and amendment of the Constitution that people are resorting to litigation. And this is not new. And indeed, I must commend the Rivers State government and the Lagos State government. You will recall, Sheon, that once in the life of the administration of Bola Ahmed Tinubu, the senator who ruled Lagos State for 8 years, he challenged the power of the federal government over urban and regional planning. And that was a form of devolution of powers. He also challenged the power to create local governments. And that has since gone around all the Federation of Nigeria, whereby various states have been able to create local government development areas. He also challenged recently the issue of inland waterways, and the Court of Appeal upheld the power of Lagos State to legislate on inland waterways. They are also challenging lottery. So I believe that generally, the judiciary can come to the rescue of Nigerians to help us run a proper federation if politicians will not honor their promises. So to that extent, the order of the Court of Appeal today, I do not think that it will extend to the laws duly passed by the Houses of Assembly of Rivers and Lagos State in respect of value-added tax.
All right. Thank you so much, Mr. Adegburua. So in breaking those down, in fact, I've a lot of the questions that I wanted to ask, you've been able to put them together in one breath. But break it down for us in layman language. Before now, in Rivers State, FRS collects VAT, income tax, in Rivers State. Before Rivers State went to the court to challenge that. And the Rivers State governor has said that come September, Rivers State will begin, based on the law in that state that has just been passed, we start collecting VAT. So in respect of Rivers State, the court today is saying FRS can continue to collect it. That's maintain of status quo. So that anyone who wants to pay tonight, we can understand it. Is that what the court means? That FRS will be the one to collect as at today in Rivers State?
Well, I think we should understand what the legal implication of the pronouncement of the Court of Appeal. When there is a judgment by a high court and there is an application for stay of execution of that judgment, you will then examine the content of that judgment. With all due respect, I believe that the judgment of the Federal High Court in Port Harcourt is purely declaratory. It only declared the right of Rivers State to collect value-added tax. There are no orders made. And so for us in law generally, our understanding is that you cannot state the execution of a judgment that only declares rights. So to that extent, we are not in a position to question the wisdom of the learned justices in the Court of Appeal. But if at all, the effect of that order to maintain status quo will be limited to this judgment of the Federal High Court. As it is now, Rivers State has two fronts in law under which it will be collecting value-added tax. It can collect it based on the judgment of the Federal High Court, but because that judgment has been stayed today, that may have been impeded. But he also has the right to collect value-added tax under the value-added tax law of Rivers State, which was passed after the judgment of the Federal High Court. So the point I'm making is this. There are two laws in contention. The first is the law being relied upon by the Federal Inland Revenue Service, which is the subject matter of the appeal that is pending. So in essence, that law is stayed by the pronouncement of the Court of Appeal. It ties the hands of the Federal Inland Revenue Service from collecting rent, from collecting VAT. The judgment of the Federal High Court, Port Harcourt, which hitherto authorized Rivers State to collect VAT, is also impeded and tied. So both the rights of FIRS under the law is tied, and the right of Rivers State under the judgment is tied. So that leaves Rivers State with the law that was passed by the House of Assembly of Rivers State, which is not a subject of any litigation, which is not a subject of any pronouncement. So the Court of Appeal has no jurisdiction, with all due respect to the learned justices, to make any pronouncement in respect of a law that is not before it. So if you ask me, therefore, it will be that as we speak tonight, this moment, the value-added tax law of Rivers State and of Lagos State are in operation. And anybody who is dissatisfied with those laws will have to go to court to get a pronouncement before he can stop the operation of those laws. So for FIRS, it cannot collect value-added tax because the Court of Appeal has asked it to stay and maintain status quo. For Rivers State, it cannot rely on the judgment to collect value-added tax, but it can fall back on the law that is in existence because that law has not been stopped by any court in Nigeria.
Mr. Adegborua, very deep and very self-explanatory. I mean, what you've said is very clear, I guess, to everyone. You've broken it down for us. Stay with us, Mr. Adegborua. Let's get some economic implication of what has happened today. Some confusion, some people say. Controversy, some people may call it. Crisis, some people may call it. But let's allow Dr. Muda Yusuf, an economist, to give us a sense of what this means. Mr. Yusuf, thank you so much for joining us. What does this mean in economic terms? What does this mean for the federal government, for the states, especially Lagos and Rivers State, that are in the forefront of this? In economic terms, break it down for us.
Yeah, thank you very much, Sean. From an investment point of view, I think there is cause to worry about the turn of events around this controversy on VAT. First, there is the issue of uncertainty that has been created as to who should administer what and all of that. To some extent, I think the pronouncement by the Court of Appeal has brought some calmness or clarity, that at least for now. So there is the issue of the uncertainty that was created. Then there's a bigger issue of the risk of multiple taxation. One of the biggest challenges that investors face today in the Nigerian economy is the challenge of multiple taxation. And this has been with us for quite a while. And this is a phenomenon that investors face at the state level, that's from the state authorities and agencies, from the federal authorities and the federal agencies, from the local authorities and the local government agencies, and sometimes even from non-state actors, like area boys and all of them. So it's a very big issue. And even for many investors, apart from paying statutory taxes to all these agencies of government at federal, state, and local government, you still pay all manner of fees, licensing fees, renewal fees, to all manner of regulators. So the burden of taxation on the investors is quite huge. Now, if you go by the interpretation by the SAN, that means we are at the risk of having two value-added tax legislation. You have the one by the states and you have the one by the federal. I think that is a source of concern to the investing community. And the earlier we have an engagement around that, possibly even outside the judicial process, I think that will go a long way. Then there's the issue of equity. I know this matter is subject, so I'm not commenting on the legal aspect of it. I'm just looking at it as it affects investors and the investing community. Now, when you collect tax, particularly something like VAT, there's a correlation between the amount of tax you collect, the volume of economic activities that takes place in a particular geographical jurisdiction, and the amount of what we call negative externalities that are created. And when I say negative externalities, I'm talking about some of the fallouts of the economic activity that generated the tax revenue in the first place. Take, for example, the activities at the Lagos port. Yes, it's a federal tax and all of that are collected there. But by virtue of all the activities at the ports, we know the implication of the port activities on the infrastructure in Lagos State. We know the implication of that for, the social infrastructure, the hospitals, the roads, the educational system, and all of that. Waste management, even crime, and the generation of slums. So a lot of these activities generate externalities which are not being reckoned with. So from the point of view of equity, I think it makes sense that in any jurisdiction where a particular revenue is being generated, a significant proportion of the proceeds should go to that entity in order to be able to support the infrastructure and facilities that the states provide to support those economic activities. Take a state like Ogun State. Ogun State has perhaps the largest concentration of manufacturing firms. And if you look at Ogun State, with the multitude of industries that they have, what are they getting from those industries? The company tax doesn't come to them. The VAT doesn't come to Ogun State. The import duty doesn't come to them. The education tax doesn't come to them. The only thing they get, essentially, is pay. That is the amount paid by the staff. And in a manufacturing setup, 90% of the staff are low-income earners. So where is the equity? That is why you go to Agbara, you go to Ogba, you go to all these Songwater, all these industrial estates. The state is struggling to provide facilities to support these factories and these manufacturing firms. So from the point of view of equity, there has to be a very strong relationship between revenue that is generated and what is given back to the jurisdictions that generate that revenue because of the negative externalities that those economic activities generate. Then there is the issue of the ease of administration. Because in the management of tax, we need to look at the ease of administration. If it is easier for the federal to collect, so be it. But what is most important in all this conversation is the equity in the allocation of what is collected. I think that is the most important thing. So that is why I think that beyond the legal engagement, there has to be other conversations to address the issue of equity in the way these things are distributed. If only to compensate for the pressure of economic activities on those states that are providing, that are generating the bulk of this revenue. It's a question of equity, justice, fairness, and even morality. So those are the things. I think that is where the emphasis should be. But it is also important that we deal with all these matters as expeditiously as possible, whether it's in the legal space or in the engagement space or whatever.
In every ramification, it's a conundrum of some sort, which needs to be unboxed, and the federal and the state governments, the constituent unit within this policy needs to sit at the table and agree, because there will be some kind of confusion. But on this program tonight, we're trying to give our audience some kind of knowledge on the kind of decision they need to take as a citizen. And so we take a break. When we come back, we still have a tax expert that will give some more insight. And Mr. Yengulam is still in our Abuja studio to give what exactly on how we can break this down so that the state and the federal government, the exclusive and the concurrent list in our constitution can be maintained in a reasonable way. Of course, Mr. Ebonlu Adegboruwa is still with us, with Dr. Muda Yusuf and Mr. Yomi Fagbenro, all of them on the program tonight to give you insight. Stay with us. We'll be right back, everyone. Thank you so much, everyone, for staying with us. We're still on the matter of the value-added tax. Some people will say consumption tax in a simple and layman language, which is causing a lot of controversy between the federal government, the FRS, the Federal Inland Revenue Service that is used to collecting it. Now they've gone to court, and the court has said maintain status quo. Rivers and Lagos State, they've signed a law on VAT. So where do we go from here? We're getting some insight with experts that are here on the program tonight. Mr. Ebonlu Adegboruwa, a senior advocate of Nigeria, who has virtually been with us on the program, sharing the perspectives and breaking these legal issues down for us. Dr. Muda Yusuf, an economist and a former DG at the LCCI, has also shared his views. Mr. Yomi Fagbenro is the West African tax leader at the Deloitte Company. And Mr. Emmanuel Anyagulam is the Executive Director, African Center for Parliamentary and Constitutional Studies, a lawyer who is also in our Abuja studio. Thank you so much, gentlemen. Let me come to you, Mr. Fagbenro. Give us a sense as an expert on what this means for anyone in Nigeria. Perhaps let's look at how some of these issues play out in other climes, similar into the kind of governance structure that we operate in Nigeria. What is obtainable in climes that are closest to us, and how do you assess what is happening presently?
All right. Thank you so much, Sheung. Maybe just by the way, I'm going to make sure that the Lagos State Internal Revenue Services imposes an extra tax on you for referring to me as Fagbenro. So my name is Olugbenro. So,
sorry,
so get ready to receive a special assessment notice for that.
Don't let me pay double. Don't let me be burdened by paying double taxes. Apologies. But thank you so much for the correction.
Thank you. Thank you. Well, I think what's happening is both interesting and intriguing, but at the same time, I think it's one that calls for serious action on everyone. So this matter touches, to the very center of our fiscal federalism conversation, devolution of power, and all of that. And I appreciate the learned perspective that the SAN had brought to this. So he's definitely the most competent person to talk about what all of the legal implications is. Now, but the truth is that one of the fundamental principles of taxation is that of certainty, right? Taxpayer need to know exactly how much it is expected to pay, at what rates, to which tax agency, at what time, and it's got to be convenient. These are, fundamental issues. And what we have on the table now touches to the very root of all of those. At the very minimum, a taxpayer can raise his hands in the air and say, look, I am totally confused. First, it was the High Court judgment that says VAT is null and void, and when a law is null and void ab initio, meaning maybe I should even be asking FRS to refund what it has collected in the first instance. And then we went on to have a separate VAT, a specific VAT law made by the Rivers State, and now there is an order of the court saying maintain status quo. Now, I haven't read a copy of the judgment, and I'm not sure whether the Court of Appeal had actually released the statement of his judgment. But what we've read in the papers are a bit, they carry different kind of connotation. In one particular instance, I read where it said that the court ordered that status quo be maintained, specifically in favor of FIRS. I don't know the extent to which that is true, and that the law passed by the Rivers State must not be implemented. I mean, I read that somewhere. I don't know whether these were exact wordings of the pronouncement of the judge. So, but what I think the taxpayer perhaps and Nigeria needs to understand is that beyond just the euphoria created by the fact that we are beginning to get states to get part of the power that they've been clamoring for through the judicial process, what is the implication for the taxpayers? How does this affect the convenience principle? How does it affect the ease of administration? And in fact, many of the states that are celebrating the decisions also need to appreciate whether this, in effect, maybe in the short to medium term, whether this, in effect, will lead to increase in revenue for them, or at the immediate, it's probably going to lead to a reduction. I mean, the jury is all out there, and we probably still need to do all of the calculation. But for the taxpayer, I think there are multiple sides to it. So there is the general consumer, every Nigerian, you and I, that goes out to purchase goods and services that are liable to VAT. This judgment, if we assume the River State law is still applicable, just like the SAN has said, the rate of tax that is, that law imposes is 7.5. If we go by the FIRS that says, well, now there's an interim injunction that says, I'm now in charge until the substantive appeal is heard, the rate of tax is also 7.5. So it means, to all intents and purposes, Nigerians in the interim will probably, for all practical purposes, still be paying 7.5% VAT to many of the vendors and businesses that they buy goods and services from. And this then gets paid over to the various taxpayers, who are the merchants and the vendors that are rendering each of those services. And so the vendors, who are the taxpayers, could then say, now I'm confused. I don't know exactly what to do or who to pay these taxes to. If I want to go by the provisions of the River State law, it means I'm operating within the jurisdiction, of River State. I'm supposed to remit it to River State. If I am operating outside of that, I then need to decide whether I am of the view that there is no federal VAT law, or I am assuming, there's a federal VAT law. What this means essentially is that the need for expedited hearing and resolution of all of this matter is quite critical. And I have heard from some of the information I saw in the media that the Court of Appeal had indeed indicated that there is going to be an expedited hearing, both of the substantive appeal and perhaps the state of execution application. What we were told is that this particular order today is neither a ruling on the substantive appeal nor on the application for stay of execution. Is to say, look, in principle, if an appeal comes before the court, parties to the suit are supposed to ordinarily maintain status quo. But you will hear some other lawyer, and SAN is on the call to say, no, an appeal does not necessarily mean we granted a stay of execution. But in furtherance to that, the court had now said, let's maintain status quo.
Mr. Olugbero,
perhaps up until, let me finish this point.
Okay.
Taxpayers do have up until, and this is where the reprieve come, and that's why I just wanted to mention that point. Taxpayers still have up until 21st day of the month, which is about 11 days or 10 days away now, during which they're supposed to file their VAT returns, for example. So there is indeed still some number of days in our hand for the court to ensure that there is an expedited hearing of all of the applications pending, so that there is clarity and there is certainty as to who the taxpayer who probably have continued to go ahead in charging consumers and buyers of goods and services, so that there can be clarity as to which agency of government at the federal or at the state level is entitled to receive VAT. We won't be the only country in the world that operates, that is operating a federal structure. And it's a matter of the law, which some countries have a state consumption tax and have a federal sales tax. Some have only at the state level. It's a matter of how your law had prescribed the practice of your VAT. As we speak at the moment, there's confusion that needs to be resolved immediately and expeditiously so that consumers, taxpayers can have clarity as to who is entitled to receive the proceeds of the VAT that they have charged prior to and after all of this conundrum that we are discussing this evening.
All right. So part of the issues that we have raised tonight, I just wanted to ask you two quick questions before I go to Mr. Anyagbulam. The first is, will any states suffer? Should we go in the way of states collecting the VAT? Would there be a case where some states will be hurt and some states will return more?
Well, the bitter truth is that the answer is a yes. Some states will suffer. Some states may, if they do things right, may be in a better position. But I can tell you for a fact that it's not going to be an easy one for any state at all, not Lagos State, not even Rivers State. And I'll tell you the reason why. When the collection is done centrally, the collection that FRS is administering as we speak, as imperfect as the system is a product of many years of practice and trying to perfect the system. Probably they've been at it for nearly 3 decades, trying to do the same. It's never going to be easy for any state to set up the collection mechanism that will match what FRS already have in place. So the ease of implementation is a major issue. And we can immediately hazard a guess by the effectiveness of the application of the personal income tax that has always been within their domain for many years. And that's on one point. The other is that when you begin the collection, let's even assume that you've perfected the collection. It is the quantum of the consumption or the business transaction that happens within your state that will determine how much you are entitled to collect. And both sides of the divide, both the state that assumes that there is a lot of economic activity happening within their domain, state like Lagos and Rivers, and some state that do think the economic activity within their state is low, needs to be very careful before they jump to a conclusion. If you pick Lagos State, for example, there is a headquarter effect of the amount that is going into the coffers of Lagos that is being collected in Lagos State. Now, when Lagos State implements, only those that are consumed within Lagos State will be payable to a Lagos State tax agency. Now, many companies that are headquartered in Lagos but also have branches spread all over the state will be obligated to remit the VAT collected with respect to many of those states. So the assumption that maybe Lagos State, generates close to 60% or whatever percentage, we use may not necessarily hold any longer because that will have been split into multiple parts. The other point is that the total amount that is being shared at the central level is the totality of what is collected across all of the states, including the one the Federal Capital Territory collects, including the VAT that the Nigerian Customs Services collect, and all of those are put, to the center. Now, when you start your respective state tax laws, you may not be entitled, depending on how the law is framed and whether the portion that the FRS is collecting, maybe via custom and the FCT, depending on whether the law is modified to allow continuous sharing or for federal government to hold on to that, it means you will no longer be entitled to share from the center.
Okay.
If that is the law. So there's a whole lot of issues that will happen. And beyond that, maybe one more point, Shehu, beyond how much less each of the state will collect, I think the taxpayer also needs immediately to recognize the implication in terms of the complexity and the difficulties of complying with a VAT law that span over 36 states of the Federation, including Federal Capital Territory, particularly for businesses that are spread all over the country, that automatically messes up the ease of paying taxes, the ease of doing businesses. So before taxpayers jubilate or feel excited over all that is happening, it's a lot of challenges that is on the table, and we all need to look at it from a total perspective to have a solution that satisfies every angle.
Oh, great. So I was going to ask you to give us maybe like a few states that may suffer in this, but maybe I'll come to that in a moment. Help me chew on that. But let me go to our Abuja studio with Mr. Emmanuel Anyegbulam. Mr. Anyegbulam, give us a sense, your expertise in this area, I want you to help bring to bear. Now, there is some kind of lacuna, which I'd like you to help us decipher where to go from here. Um, we do not know how this is captured. Some people are saying, clamoring that this issue should be put on the exclusive list. Where does this belong? Where does it rightly should belong compared to other federal states across the world?
Well, actually, it's a very interesting development in our history of federalism. This law, if you take a very good look at it, emanated from the military era when they started the VAT regime. Definitely, it came in as a transition and existing law, which brings the problem or the issue of law reform and review, which we were supposed to do every 10 years. The only one we have done in 22 years was the one in 2004. Law of the Federation is still 2004. So we have been trying to grapple with a lot of issues, and this has raised this particular issue. And then the issue, secondly, of public revenue within our Constitution. If you go from section 162 of the Constitution, so what has really come to light, in every federal structure, the states are not uniform. We answer a federation in name and then practice unitary system. It has now brought a very interesting issue of where the taxing powers lies. Just like, I won't go to the other areas because the SAN has covered the Fed basically on that. So the main issue now, let's take the first federal state, which we copied their constitution, if you say to a reasonable extent, in United States of America. States like Arkansas and the rest of them, who are very, by every estimation, poor, they have within their own limit what they do. Even the governors of the states don't earn the same salary. Here you have even poor states. The governors will fly private jets, hire private jets, or have their own jets. Like we saw what happened in Taraba then under the, though it was an unfortunate issue, but the governor then had to hire, buy with poor state funds 2 airplanes. And on practicing that, it was a very unfortunate issue. So let's take it like that with Taraba. But what we are saying now is, if we want to come to the table with reasonable and conscious effort on federalism, this has raised a critical issue. If we do that, we will see that Lagos State, yes, because of population and gauge, may have a different perspective from states like Taraba or Kebbi and the rest of them. So now if we think that we will go on a federal structure, like we have heard about restructuring and the clamoring, this brings this to bear. But what I am harping on is that if we have a critical review, not only of our constitution, but the laws so far, we will be able to address these issues. It is not as easy as it seems to be, because most of the states cannot even have the capacity to collect the revenues. And then another issue at stake is, like you rightly said, if you look at the Constitution, taxation is not within exclusive lists per se. Neither was it highlighted, but you will see trade within the exclusive list. Then if you go to public revenues, from the suitable pool account where all of us run to, and the issue of revenues that we collected, and then have a deal of when you collect, you see back. So now what I'm saying is that if we can move constructively, we have Law Reform Commission that has been moribund, more or less. Let me say that. Then we have advanced legal studies and the rest of them. Then professionals should come to bear and appraise these issues. If we allow states, by this example, if they have the competence really to make a law, like the senior advocate rightly said, until you go and challenge these laws and declare them null and void, if not, they are effective laws, because in federalism, there is what? Underlying principle of non-interference in the affairs of the states. So if they have made these laws, but the ultimate issue, take issue of electricity, that is an exclusive issue in the Constitution. Now, who collects? Or do you subject us to double taxation in area of COVID regime and the level of hardship we are going through in this country? So these are the areas we will think of. Then there is VAT on accounts in the banks. If I have that in account, if I have so many accounts, will the states come into it because of VAT? So what we are thinking of is that, like I said, we should go back to the drawing board. Take a holistic look, not only on taxation alone. Most of these decrees are no longer suitable for our current democratic regime. And then the states will now be able to wake up to a clarion call, to know where their own interest lies and where their capacity lies.
All right.
I have always said it is beyond establishing universities and technology. Some of them have up to 3 of them they cannot run. So effectively, this is a clarion call for all of us to reappraise ourselves and then know what to do.
All right, Mr. Yegulam, quickly, let me jump in. I'd like you to touch quickly on this one. There are a few states in the Federation who are also interested in the way Amana, Rivers, and Lagos have gone. But Kogi State has said they won't go in the way of Rivers and Lagos State. I understand that Akwa Ibom and a few states want to go in the manner in which Lagos and Rivers have gone. But in recent time, we've seen state governments and governors that have come together to challenge the powers, the stance of the federal government, or the capacity of the federal government. We've seen that happen in the issue of the stamp duty. We've seen that happen in the Paris Club refund and how it should be shared, the promissory note, the report that have been circulated. But what do you make of this new trend of the state versus the federal structure?
It is a very interesting area because each state is a full entity of its own who can go on. I appreciated the states going on their own. Then, if other states will join. But the irony is that within 2 steps, you have gone through a typical federal setting. Then you march back 3 years, you see the same states going back again to go on basically unitary stands. They go on uniform stand for 3 steps and then come to federal issue. So if we can have the states take their stance, like we said, in federalism, you have your independence as a component area, then you channel your abilities to what you can do. But the issue is that when we think of a federal structure, on the other hand, we behave as if it's a unitary system. Then the federal government will be big stick. So if we can do, you've seen when they have roads, they call the president to come and commission roads, which are legacy roads and the rest of them. Then the political parties who have no vision whatsoever, because these are issues for public governance, since we have taken political parties as the only vehicle to elective positions in this country, they have much to do by their programs and actions. And like I have said, VAT is a very old regime in almost every part of the country, of the world. So it should not be a new issue if we are proactive and responsible to the oath we take to protect, defend, and preserve the Constitution of the Federal Republic of Nigeria. And like I have always said, the best law is the welfare of the state. So let us save ourselves from double or multiple taxation. We are not ready, we are not at ease with what is happening with the problems we have in hand. And let this not deepen it. That's my submission.
All right, let's close the program now. But I'd like the experts in the room to just share their views, just in about 30 seconds, their final thought. Let me begin with the senior advocate. What's your final thought, just in about 30 seconds?
In respect of the implementation of value-added tax,
absolutely, on the matter generally. Your final view on, on this, just in 30 seconds.
The Federal Inland Revenue Service is a judgment debtor. A power to collect VAT has been nullified by a competent court. The best that happened today is the suspension of the execution of the judgment. That cannot authorize FIRS to demand tax or collect it. The best would be that This appeal should be heard expeditiously. The rights of the party should be determined. There's no confusion at all. Thank you very much.
Thank you so much, Mr. Adegborua. Dr. Yusuf, your final thought in 30 seconds, please.
Well, I think there is need for expeditious hearing, as the SEN has said. Then there should also be a honest conversation around the issues of equity in the allocation of the proceeds of VAT. And we should, as much as possible, avoid a situation where we're having multiple VAT laws. Because we don't want to end up with a situation where we have the state VAT law and the federal VAT law. As much as possible, we should avoid that, because the investing community already has enough trouble already around issues of multiple taxation.
All right. Mr. Olugbenro, your final thought.
Well, thank you, Seun. So again, two points. The first is that expeditious hearing of this case is very paramount, it's critical. So we need to get our court to assist in providing certainty and clearing whatever is the doubt or confusion that we have in the system. The second is that I think there is a fundamental issue that also needs to be fixed with our constitution. So the lacuna that generated all of this in the first instance is the fact that there was a gap on the exclusive legislative list where VAT wasn't mentioned, and VAT was a National Assembly legislation. We need to fix that so that we don't have a repeat of this going forward.
Mr. Yegbulam, you give us the final word.
Well, having run a presidential system for 22 years, military decrees are no longer suitable to our situation. So the situation calls for immediate law reform and law review. We have a commission for that, and there are also expert institutions we must align to make our democracy worth it.
If I have my way, the gentlemen that have spoken tonight, we should gazette their opinions, and maybe it will be useful for the federal government or the state government to get a headway in all of this. Well, that's just my opinion anyways. But I must sincerely thank the panel tonight. From the Senior Advocate of Nigeria, Mr. Ebonolu Adegborua, thank you so much for coming tonight. Dr. Muda Yusuf, former DG of the SEC and economist, and Mr. Yomi Olugbenro. Apologies for getting your name wrong in the first place. Thank you so much, Mr. Olugbenro, for coming. And Mr. Emmanuel Ayegbolam, a lawyer who has been talking to us from our Abuja studio. Thank you so much, gentlemen. It's a pleasure having you to share your views on this. And I hope that as viewers, you've gotten some insight into it and you can take the right action. Thank you so much for watching. Until I see you again on Sunday at 8 p.m., I'm Seun Akimale. Bye for now.